matter is about 2015.
Hmm.
Item 100.
Hmm.
They want me my service. So I know 2006 told her very embarrassing to ask the court. So what I pray is only for a week. Let me take it for. There is some question of law is involved. Whether they can classify category.
Yes, whether they
make
can
category.
already schedule is
category.
there. Yes.
27 of the, I have to go a bit detail.
Huh.
27 add to the schedule. Adding to the schedule
Is whether which
whether
permit
they need, whether they are permitted. That's a very important issue, legal issue, because it will have a great ramification.
Yes, yes.
Only on Tuesday it can take.
Okay.
I not ask much.
Okay. What to do then? It was a part hard matter.
Let it part. Let it part can be taken. Well,
On the yes, sir. Union who will represent the state in this case? It's a serious issue, madam. You'll have to do properly because they are important issues. Whether you are having the power itself is the question.
Right.
As agreed to by the learned counsel for the parties, release this matter for further hearing on 12. We request, Madam, we requested Mr. Gogoi to be present.
Yes.
Huh? Tell him on Tuesday, let him prepare and come. Yes.
Regarding item number 13, maybe my senior is having a medical checkup today. I prayed for Thursday.
2014.
But actually,
You are for petitioner respondent.
I'm
It's submitted that who is your senior?
keyboard.
Huh?
Keyboard.
D. Borua, learned counsel is having is indisposed today, according to prayer for adjournment.
In remote.
Prayer says allowed. Release this matter on Thursday. Possible? 7th of
14th.
14th. 14th of interim order passed earlier. Shall continue.
Item number 40, 50. This heard by different men.
No, that cannot be. That submission was made on earlier occasion. That was placed before the Honorable Chief Justice. And since its time is over, does not kept as part of, so it will come in as per.
In that case, may pray for taking the matter. We were in the
No. That order was passed on last occasion and was placed before the Honorable Chief Justice, and it should be treated as per order. All these are 2014 matters. If all are adjourned, what will you do? Yes. When? 14? 15? 15 is it? I cannot. Give next, 19. 14, now 19.
I want to mention one WPC for listing in hearing in the year of
You go to the other bench. This is the second bench. Yes, next.
like to mention for district of bail application.
Rejected by this.
Lordship this previous bail application with respect to same FIR was about this bench. The written
No, you make a mention before the criminal bench, automatically it will come in.
lordship in terms of Supreme Court order.
No, we know that
all
Supreme Court order will be looked into by the registry. Is not it? You make a mention before the criminal bench. When it is permitted, it registry will verify and it will be listed here. Okay. You make a mention before that.
this case matter around 6 to up to the case that you was called for.
Hmm.
But after this you have not received matter on. So it is next week on 13 or
Great case study next week. When? Give it
14, my lord.
14.
But there is an
Interim order passed.
first of that.
That bank whether that document.
Yes, sir.
First that.
Order. Let us take a call. Okay. Yes, Mr. Kejriwal, is anything to be done in item number 11? IA for
For
amendment.
of the brain.
Since
The pleadings are already there
Ah.
between the affidavit evidence, they can be allowed in the matter.
allowed means we need to hear the other side. We'll have to issue a notice.
If- if-
Okay,
Yes,
let it come. Okay, continue. Yes. Yes.
the constitution for the
Item. Get the next item. Next item. That is the two represents again. Mr. Gogoi, there is a matter, item 1 and 2. It is an important issue. So we requested to reflect your name. That is reflected. We have fixed it on 12. This is a matter of 2015. A legal issue is there regarding wages. So you come prepared.
last for I because getting my lot appointment.
Hmm.
My lot that for their affidavit my lot was appointed to get up my
Hmm.
so they the service has special appointment but the support therefore my lot might conduct the regular
Okay, fine. But how do you explain the delay?
delay.
You are all along aware of your salary, everything.
Yes.
Till your retirement, you have not done. Even when you will given the benefit of Upendas, then also you have not done.
Yes.
How a writ court can help such a litigant? There are two aspects. Of course, there is no question of any limitation, law of limitation applicable in a writ proceeding. That is clear. Let us be clear. But what about laches on your part? Now see the situation. Even we don't have the record. When was your appointment? Huh? 94. 94 and we are in 2024. So how can we cannot blame that and we cannot pass a judgment with on air only on your submission that this was a compassionate appointment.
But the it say
Hmm.
on date of my husband I was
Yes, of course. Appointed. So now do you expect this writ court to go back and determine everything? That was the issue where you'll have to satisfy. Law is against you. Law is against you.
the point of delay man that I'm not claiming the salary of that area. Only the internal benefits man. That case of Emma Gupta would have put that the passing right for the
No, pension is a persisting right. No issue on that. But whether you are entitled for pension or whether your appointment ought to have been a regular appointment under scheme regular scale of pay was to be determined in the year 1994, at best 95. At best when you were given the benefit of Upendas. Let's see, don't give me this benefit. You have raised this issue after your pension. After your pension, that is after 94 to 24, how many years? 30 years. Can a writ court give a relief and pension at this stage? And because it is not a question of pension, non-granting of something like that. It is a determination whether you are entitled for benefit. We given serious thought. But We cannot pass orders on sympathy.
At the point of petrol,
Hmm.
petrol, but submission,
Hmm.
because the certificate of petrol.
Hmm.
That's the root
That temporary. Okay, let us you argue that how that temporary will cover you. Then every temporary casual employed daily wage earners will have a pensionable right. Pension. Some pension. Material. Yes, rule 30.
The service of an officer does not qualify for pension unless it confirms the following sequence.
Hmm.
The service must be under the government. Second, the employment must be substantive and permanent.
Hmm.
Thirdly, the service must be paid by the government, provided that governor may, even though either or both of condition 1 and 2 above are not fulfilled, declare that any specified kind of service rendered in a non-resident capacity shall qualify for pension. But if the first two conditions are not fulfilled,
Hmm.
governor can declare the certificate pensionable. But in my case, my lord, I have uh, fulfilled the condition 1 and 3. Service must be under the government. Because under the government. Third, third condition is the service must be paid by the government. As paid by the government. Third, by exercising the provision under
So you want to propose that in case of a casual employee or daily wage earner, the governor is empowered to declare that a casual for this casual service or daily wage earning, you will be entitled for pension.
and satisfy because they have those memoranda.
Now you will have to give certain importance to certain words. Legislature has not enacted this. Read this once again.
Service of an officer
No, declare that.
declare that any specified
Go
kind of
slow.
service
Any specified kind of service rendered in a non-gazetted capacity shall qualify for pension. When you are lack of qualifying service, this prescription is given. Not for everybody and anybody. Suppose you lack a qualifying service. Suppose in case of that employees who were regularized, but their service, though they were continuing since long, since they were brought to a government fold, their qualifying service of 10 years or 15 years was not there. So governor can declare, okay, your service rendered as a master role or casual will be counted for the purpose of pension.
normally बोला that is the interpretation
हाँ,
to the rule
it
31.
that given. So if you propose to say that governor will have a power even to declare that you will be entitled for a pension, for a pension, even if you are a casual or master role worker, without service being brought in under government. Do you propose to say that?
And if we read, if we read my lord rule 31 along
Hmm.
with the memorandum matter at
Hmm.
page 3 and 5, it
Any
query
specific?
page 3,
Page
53 of my additional affidavit.
page 53 of which petition 6919
Yes.
4232.
4 to 6.
Page
56. Which order the page 12.
Now tell us, what do you mean by temporary government employee and temporary service?
Like a picture that all separate.
Uh-huh.
Sir, my lord, it's the third that post declared damage. If the body or not, if it, my lord, declared that my lord, on terms of when even kilo pay was given, they cannot take the my lord with that.
What is this next last line? Subject to the condition. This is, however, last three lines. This is, however.
This is, however, subject to condition that they satisfy all conditions other than the condition of permanence against permanent post under the government or district council or
So what is the permanency against permanent post? And what is the temporary in the context of this regulation? Do you want to interpret this temporary by this code for the purpose of pension all casual or daily wage earners who has rendered 20 years of service under government to be a temporary employee, therefore they are entitled for pension. So therefore you'll have to satisfy what is the meaning of temporary employee and temporary service and permanency against permanent post under the pension.
Your Lordship, Peru's Rule 42.
Rule 42.
Rule 42.
Just a minute. Rule 42 of pension rules.
For the place
Hmm.
as per the way of government.
Just a minute. 40. Yes.
If base employee is paid for shall be treated as pensionable term if he is employed not graduate but as a member of a fixed pay subject
Hmm.
during the last 72 months of his actual employment. He has been attached one of his uninterrupted for 24 months or has not been through his own choice or conduct that has not been to attack.
Hmm.
Has rendered continuous service for 25.
Hmm.
Both one.
Hmm.
Continuous service for 25 years with count for pension in the case of temporary peace workers and all temporary salaries and in
There you might have.
some 42 section of the government.
So you want to say that press employee, there is a press employee are being treated as a different class of employee and pensionable.
The
And
rule
if that is your argument, then rule 31, 32 will not come. Why are you arguing that?
of the 42
This should be your argument that these conditions, 31 temporary, why are you arguing all this? Yeah, why should you argue general? It should be a specific case that I am in X1, I have been created as a special class of employees for entitlement of pension, and whereas from rule 31 is the general condition. Rule 32 is explanation of what is service under government. Okay. Rule 34 is service, what is the payment by the condition. Rule 36 is the general principles. Okay. Then rule 40 is the permanent of what is permanent office. Now rule 40, what is substantive office abolished. These are not applicable by virtue of rule 42. This is in exclusion of rule 31. That should be your argument. Now judge will argue on your behalf. Isn't it? Yes, Mr. Sutia, here you will have to explain. What do you mean by a press employee and who is paid for piecework? What is piecework?
I don't know, my lord. I know only this case is squarely covered by the open desk case. I have gone through it twice. I have read it. Lordship kindly see why this further argument is not necessary. Pension rule is not necessary. This matter has been settled by the division bench. Lordship, thereafter, my lord, further argument by learned pen. One thing, my lord, he was also one of the respondents in this open desk case, my lord. He appeared. Yes. The core issue, the core issue which calls for our consideration is whether, in the fact situation of the case, the respondents who are master workers, workers employees, and casual workers are entitled for regulation of their services with consequential benefit such as pension. That is the core issue. Now, after discussion of the Umartibi case, other case also, the court has come to the conclusion, my lord, paragraph 22. It is, however, heartening to learn that the state government has agreed not to terminate the master workers and similarly placed employees working since last more than 10 years, not against sanction 4, till their normal retirement, except on disciplinary ground or a ground of criminal offences. The state government has also agreed enlist such employees in a health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate that this positive stand of the state government taken in welfare measures for the betterment and security of the employees. In question, we accordingly direct the state government to implement the measures without further delay. Besides this, we, in the light of the decision of the state of Punjab versus Jagdish Singh, so direct the state government to pay minimum of pay scale to the master workers, and similarly place employees working since last more than 10 years, not in the sanction post, with effect from the 1/8/2017. And 1/8/2017, on the basis of that judgment, my lord, Finance Department has issued this notification, in effect from 1/8/2017. For the reasons, we are of the view that the fact situation of the case, master worker, casual employee are not entitled for regulation of their services with consequential benefits such as pension, etc. We accordingly subject to our direction, paragraph 12. So it is squarely covered, my lord. Lordship, on the basis of this order, Finance Department issued, my lord, notification. That I have annexed this from Finance Department in Monwara case. On the basis of that, they are getting 50,000 something scale. And she is enjoying it. Last retired. Now she is coming abruptly that I would have been, my lord, so and so, I would have been treated so and so. It's not case.
Okay, forget about the first part.
Yes.
Forget about the first part.
Yes.
Now his contention is that I have a statutory, even I am a casual worker or a daily wage earner. Statutorily, I am entitled for promotion with certain conditions, and I have satisfied that.
That is not satisfied, my lord. He is actually not entitled. After the division bench, he will have to go for Supreme Court.
No. Her case, we'll decide
Okay,
that.
yes, sir.
Her case is that as regards that is regularization. If you have not regularized, forget about that. Because you have not regularized.
Regular.
But a person who is not even regularized and employed in press are being created as a separate class under Rule 42 of the pension rules, and it is made a pensionable service. So even I am a casual worker, even I am getting a salary under Upendas,
Upendas.
I am entitled for pension under Rule 42.
That is no. How he will be entitled after receiving this amount of receiving extra pension, the Upendas case ballot, how she can claim it after retirement? Now,
No, she is claiming, saying that I have a statutory right.
no, man. She is ballot. I am going for
No,
it.
no, just answer that. No will not do. You will have to
No.
say that these conditions are not. Now let us come to Rule 42. Okay. That is her, we want your response. That is his argument. We are not accepting that
Yes.
for the time being, until and unless we are satisfied. A press employee. What do you mean by a press employee?
Peace
This is-
employee.
huh?
Peace
No, no, press employee.
press
Rule
employee.
42.
I know only media press. I don't know otherwise.
No, government,
press employee.
therefore, just, you will have to, you will have to satisfy this code. A press employee. She was an employee under government press. So she claims, I am a press employee. Now, what is the definition of a press employee under the pension rule or any other rule? That is the first determination. Who is paid for piecework? What is piecework? So first condition is payment, a press employee. First condition is paid in piecework. Shall be treated as a pensionable service. Okay?
Yes.
So we'll
If-
have to clarify what is a press employee and what is a piecework. If
Yes.
she is satisfied that I am a press employee and I was paid for piecework, first two conditions satisfied. Second, subject to other conditions. Dear,
He is
if
employed.
he is employed not casually but a member of a fixed establishment. You may say she was a casual employee everywhere it is there. It was not a fixed in a fixed
His
establishment.
establishment means
Two,
treating.
during 72 months of his actual employed, he has been attached to one office uninterruptedly for 24 months. His second condition, he has rendered continuous service of 25 years.
It has not been.
Now, note 1, she says, continuous service of 25 years will count from pension in case of all temporary piece workers and all temporary salaried hands in Assam government press. So she claims Assam government place. However, she will have to establish that she is not she is employed not casually but as a member of fixed. What is this? Where is the pleading?
Yes.
This is a new development. How he will respond?
See, yes. Without pleadings, I cannot respond it. And there is several. That's been also.
No. Question of law is whether a press employee is entitled. Whether you are a press employee under the definition of 42 is a question
Yes.
of fact. Isn't it? Is it a question of law? It's a question of fact. Without the pleading of the question of fact, how does state will respond? Because this is a new thought.
As in note 1, my it has been explained that the temporary workers with open placement. They are
No, continuous service of 25 years is only a one condition. Suppose you satisfy that. What about 1 and 2? This is so far relating to condition 3. Condition 3 says he has rendered continuous service of 25 years. And what is this 25 years is explained at note 1. Fine. So that condition is satisfied. What about 1 and 2? Where is the fact?
Again, I will be reading it. A press employee, who is paid for piecework shall be treated as pensionable service if he is employed not casually. That means the permanent employee. Permanent employee, he is today is in press. What happens to printing press? He is engaged for printing. He is for publicity.
That is the response we want from you.
Yes,
Not Upenda.
Pleading is not the. How can I receive it?
No, you interpret it. He is an employee, not casually. His admission in the pleading is that my appointment was casual appointment, daily wage earner. Everywhere it is appointment and casual. Therefore, he is not ethical. That can be your argument.
Yes. On the basis of that.
But we want the argument from you.
Yes.
Not from us.
Yes, I will argue. I
I am arguing on his behalf and again arguing
No.
on
I am denying this ballot 42 is not applicable in this petition
Ah,
because he is not an employee of the press.
okay.
Press means he is employed not casually. That means permanent employee. Those who are permanently employed.
So
in
your
the
argument should be even if it is assumed that he is a press employee or paid in piecework, she was appointed casually.
press, casually.
So
Okay.
first, if the first condition is not fulfilled,
Yes.
then we'll not go further.
Then during the last 72 months of his actual employment,
Hmm.
he has been attached to one office of
That is case satisfied. Last 72 months he was in one place, fixed salary. Okay, fine. That condition is fulfilled. Third is also fulfilled. But fundamental condition is not casually, but as a member of a fixed
yes,
establishment.
member of means permanent.
Where is your statement? Your statement is that I am a casual employee, daily wage earner. They ought to have appointed me in compassionate.
Paragraph 4.
Paragraph.
Paragraph 4. The 47. 7th line from Peter.
Paragraph.
4. 6, 7. Moreover,
No, before moreover come to the first line. Moreover will come later on.
Right.
Oh, that the petitioner begs to say that after she was engaged on master role basis. So your engagement was on master role basis, admittedly.
Paragraph 4.
So what is this? Moreover, where is
moreover, her salary is
that?
page 7 matter.
Page 7.
Yes.
7 even before the authorities praying for her appointment or result.
6 line from Peter. Line from
We can post an authorities are delaying her.
Her salaries, wages were also paid on monthly basis, regularly like that of a regular government servant. He was also
I am
engaged in a
in WPC 6919.
Thakuria.
4
Huh?
to 3. 4.
Second case. Vijaya Thakur.
Page
Page 7.
Hmm.
6 line from Peter. Moreover, her salary wages were paid
page
page 7 matter.
page 7.
Paragraph 4.
Paragraph
4.
4.
Line from Peter.
Hmm.
Moreover, her salary wages were paid on monthly basis regularly, like that of a regular government servant.
No, salaries, wages paid as a regular government servant, but not a scale. You are a casual everywhere. It is your own statement.
We have answered it, my lord, our epidemic.
Hmm.
Our answer it, my lord, against this paragraph.
Hmm.
We go to the petition, the deponent back to state that petitioner was engaged as daily wages casual employee in this director of printing and stationery firm. After expiry of petitioner husband, so and so. He was not appointed as a master worker as pension is a duty. Her wages was paid monthly on daily wage basis, unlike that was regular government. That means her daily not paying daily, it was accumulated and in the completion of a month, he was paid altogether, whatever may be 300, 400 multiplied to the 30 days. That is, this does not mean he is drawing salaries, pay scale, so and so, so and so. Her appointment is not there. She is engaged only casual. They are only registered is there, casual employee. How she can claim the pension? Now, Upenda's case, after discussion, all these things are declared that
No, Upendas is not relevant here.
no
Whatever he is getting benefit is Upendas is basically regulation. It is her
regulation and pension also one.
no, not
No.
pension.
Yes.
Upendas is absolutely regulation. Court says we are in view of Uma Devi, we are our hands are off.
Yes.
But however, government has taken a decision and government has taken, we welcome it, do it. Accordingly, government issued a notification. I have not seen any ratio laid down in Upendas. Upendas penultimate thing is government has done it. We are thank you very much.
That is the
Is not it?
Yes, my lord,
The
core
ratio
issue,
was
core
minimum
issue, my
scale
lord.
of pay
Thank you
and
very much. You do it very good. We appreciate because they are otherwise entitled under the thing. That's all.
The
was decided
core
in
issue, my
the
lord,
case of
workers
domestic violence.
entitled for regulation of their services with consequential benefits.
No,
unless-
that answer is no.
No,
That answer is no.
Yes.
Where is the answer to that question? That has not been granted.
and so far, the petitioner claim is her after her
Her
death,
claim is that
she was
what I could understand, her claim is that my appointment was pursuant to death of my husband.
husband. It is called
That is not,
compassionate appointment.
therefore, that ought to have been a compassionate appointment in a regular scale of pay.
pay.
First,
Yes,
that has not been given in the year 1994.
94.
She continued till 2024.
Four.
In between, she was granted benefit of Upendas.
Upendas.
Finally, when she retired, she has become wise and claims that I should be granted pension. Now, her whole case in this writ petition is that you have committed a mistake when appointing
1994.
me, 1994, correct it and pay me pension.
But
now,
after
when
30 years.
he was confronted with many tough questions, now he has developed a argument under 42, saying that I am exclusion to this rule and I should be granted pension in terms of I have a statutory rule. Now, statutory rule on her own pleading, she has not fulfilled the condition one, though even if we assume that she is an employee, piecework employee under press, even if we assume first condition is not fulfilled,
fulfilled.
therefore she is not entitled for pension.
So for compassionate appointment
Huh?
is concerned, my lord. Yes, exactly.
This is your argument.
My case that I was paid monthly salary.
Hmm.
Paid monthly salary.
Okay, we have given enough time.
Even my lord, I was debate the minimum scale of pay of. So my lord, I am entitled to.
Okay, argument over.
Over.
As because
So far, compassionate appointment, my lord, I am pressing this for Lord Supreme Court. Paragraph
if you judgment, my lord, I have the counterpart.
18.
Getting gratuity, payment of gratuity.
Oh, what about gratuity?
No, gratuity, I don't know, my lord. Gratuity is not entitled, my lord. Not entitled. So he is receiving the benefit of open dust under there. There is no gratuity and pension. Only that part. Whatever the amount was given to all employees.
What do you argue on gratuity?
Gratuity, my lord, under the Gratuity Act, my lord, he has the right to get the gratuity.
Hmm.
It got my lord, the act, my lord, for my lord, amount fee, my lord. Initially, it was 10 lakh, but subsequently, 2018, the act was amended. Amended has been held to my lord 20 lakh. And has been settled by the Tripura High Court to my lord, by a different bench of Tripura High Court, my lord.
Which judgment you are relying on?
My lord, as because the gratuity, my lord.
Huh? Any judgment on that?
Yes, sir.
That casual and daily wage earners are entitled
Court illegal
by apex court.
by the Tripura High Court, my lord, by division bench of.
And there is a judgment from Karnataka High Court. Okay. We'll consider.
Right.
CAB.
So far, relief is concerned, not pleaded case, my lord. I have a case, my lord. Not second.
Give her all your judgments will pass this. CAB. এখন পড়েগা।
Obligation.
Okay.
May I please your question, Madam?
Yes.
Here, my lord, in the instant case, my lord,
Hmm.
the value of tender is the, my lord, 5 crore, my lord, 61 lakh.
Now, thing is that in the year 2014, Railway Board clarified. In the year 2018, we have accordingly we issued a notification, and the tender is of 2019. 2019. Therefore, you are aware of this thing, and second, you are aware of this thing. So therefore, you are not entitled. This is their
Yes,
case.
yes.
Now, according to you, what is in the contract? Special condition of contracts, and
Yes.
what is in the general
Yes, the special condition of contract, my lord,
Ah.
so far relating to this aspect of the contract,
Ah.
nothing has been said. Only condition is that, my lord, if the tender value is, my lord, below than 5 crore, then, my lord,
Where is that?
your lordship,
We want the special condition
yes,
of
ma'am.
contract.
your lordship kindly come to page 26 of the my paper.
Page 26.
Page 27, sir. Point number 6,
Page
price
20,
variation.
just a minute. Page 26.
27, ma'am.
Page 27.
6, ma'am.
It's a special condition, is not it?
Yes, my lord. Special condition, price variation clause.
This is tender notice.
Yes, my lord. Price variation clause is not.
Where is your contract entered into between them?
Less than value, rupees 5 crore. Your lordship kindly come to page 31, madam. And your lordship kindly go through this, that I take the whole contract agreement, madam.
Where is that?
Yes, ma'am. If you are looking to go through this whole contract agreement, my lord,
Hmm.
nowhere it is stated like this, my lord, about this guideline which has been mentioned.
No, no, any price variation clause.
Price variation clause, my lord.
Hmm.
It's available, my lord. May I- Page, my lord. That page is, my lord. In petition, your lordship will get page 34, my lord. Same, my lord. 46.1.
This is the contract.
Contract agreement between us.
Okay.
Nowhere it is stated.
Here is a clause which says price variation clause shall be applicable only in those contracts where tender conditions specifically permit it.
Yes, that is the tender condition.
Okay. So that is the tender.
Yeah.
Now, what they are relying on GCC.
They are relying on GCC 2014.
GCC 2014.
GCC 2014 said nothing about
No, no,
only
no. Just let me understand. In your case, which GCC will be applicable?
2019.
2019
Yes, my lord.
GCC.
Because
Now,
I'm coming, my
notification
lord,
was
because
issued.
this GCC has come on, my lord, September 6, 9, 2019. And tender has been posted on, my lord.
Tender is there. That's why
December.
I, on last occasion, I asked the dates.
Yes, my lord.
Tender was floated on when?
December 13, 12, 2019.
13/12/2019.
Yes, sir.
Now, GCC,
GCC on, my lord, 6, 9, 2019.
GCC 6/9/2019.
Your lord, can-
We'll come to that later on. Okay. Now, contract was executed on Contract was executed on
2020.
28/8/2020. Okay, so your simple case is that in terms of the tender,
Yes, sir.
I am entitled for price value variation because it is the value of the tender,
Yes,
not
sir.
the contract.
Contract.
Okay, this is your first step.
Yes.
And you say that in my special condition of contract, it
Yes.
is said that it will be applicable when it is provided in the GCC.
Yes, sir.
Okay,
Yes, sir.
when it is provided in the tender condition.
And the contract.
So according to you,
Yes, sir.
it is in the tender condition,
Yes.
it is in the special condition of contract.
Contract.
Now, what the GCC of 2019 says
2008, 19, my lord, if your lord.
regarding
Yes,
price
my lord.
variation.
Yes, my lord. Yes, my lord. Your lord, what is the thing to lay? Now,
No, press 34 is SCC, is not it?
oh, my lord.
Part of the
That is also part of. No, this is 46A.
It's
part of the
Page 62, my lord. Sorry, my lord.
Yes,
Page 62, my lord. I'm giving my lord. This is.
page 62.
Yes, my lord. That's available in the.
Page. Page. Okay, page 34.
Of the petition, and this is the page 62.
Just a minute. So what is the page of the tender?
Hello?
Page of the tender? Page number?
64.
Huh?
Page 34.
No, page 34 is the GCC.
Yes, my lord.
Page of the tender,
Page 26.
26. And contract you have given me separately.
Yes, my lord.
Okay. Now they say that see, we have interpreted, Railway Board has interpreted this tender value remains a tender value, this contract is signed. When the contract is signed, it is the contract value which will be the determining factor. Therefore, when your offer is less than 5 crore, when you do not come under the PVC, therefore it is our decision. How can read court interpret?
if-
This is their case.
Yes, my lord. Absolutely.
Hmm.
Where is that condition, my lord? Whether they have up to that all these things, my lord. That is the important thing, my lord. Suppose, my lord, if the thing is available,
Hmm.
then that is different aspect of the matter. They about say 2014, subsequently 2018 come, my lord. If you are close to the, my lord, 2018 document, my lord, then also say it is a contract tender, my lord. What is the tender? Not contract. I am coming later on, my lord. What is their, my lord, decision? Your lordship kindly paste, my lord, 57, my lord. That is important. Of the, my lord, tender.
Of base,
Page 57. Because, my lord, after CCL and others, my lord, other still and other has gone, my lord. They cannot, my lord, they should interpret, my lord, on the document producing the tender, my lord. And, my lord, if any document they want to, my lord, rely on, that should be, my lord, uploaded. They cannot take here and there one document, my lord, stage. And if you lordship go to their affidavit, I will go also give that. Then this is page 57. They said, as per item number 8 of Railway Board letter mentioned above, place SN 36B. PVC is not applicable in all work tender having less than rupees 5 crore. The instant tender was calling a value of rupees 5 crore 61 lakh as per NIT, copy place SN 38. Accordingly, PVC clause is incorporated in the tender document as well in conduct agreement based on GCC 2019. Railway board letter number so and so, so and so, so and so, so and so in view of the PVC may be forwarded in for vetting fees. That is the decision. The GCC 2019 has Railway board letter number 2000 copy enclosed SN 30 is related to GCC 2045. But the instant tender is under GCC 2000. Have you looked at it, my lord?
Yes, yes.
That is my case, my lord. It is completely on GCC 2019, my lord. Whether they said, my lord, that retrospective GCC will follow 2014.
Okay, this is your case.
Yes, my lord. And he is the person, my lord, who is my lord floated tender. And another important thing is that, my lord, they have stated in their affidavit, my lord, 2018 letter, my lord. Although they cannot rely on this, my lord, I have already submitted, my lord, because this is not part of tender document, nothing, my lord. If your lordship go to my lord, here, my lord, part 0.80, 84,
Base.
84, my running page. Price variation clause, PVC.
Page 84.
Yes, my lord.
Project price variation.
Ah.
Yes.
Price variation clause in work conduct is dealt in accordance with the provision of July, this is 46A, July 2014. That is for July 2014 GCC addendum, my lord. This is not 2019 GCC, my lord. In order of simplify, enhance the pace, it was decided to remove PVC clause in all work contract tender. Tender, my lord. What has been used tender? If having value less than 5 crore, my lord. This is my submission, my lord.
Okay.
Preliminary submission.
What remains then?
If he says something, my lord, I have to keep.
That is a reply.
Yes, my lord.
You have concluded. Anything you want to rely?
Yes, my lord. I am relying, my lord, on my lord, Tandia construction, my lord. This is not the absolute power, my lord.
India.
Yes, sir.
Citation. Paragraph.
Citation, my 2011 5 SSC, my lord,
2011 5 SCC
697.
697. Paragraph.
Paragraph 30 is the operative part. It will not go.
Paragraph 33.
Yes, my lord. May I read that?
Yes.
Yes, sir. Paragraph 30. Here in the instant case, my lord, what happened? In this case, they want to give some extra work. And they said that that should be completed within a stipulated period, my lord. Then this comes, they have said that the employer has said we are invoking arbitration clause. And thereafter, after all discussion said, apart from the above, even on the question of maintainability of the repetition on account of arbitration clause included an agreement between the party, it is now well settled that alternative remedy is not an absolute bar to invocation of jurisdiction of the High Court or Supreme Court without exhausting such alternative agreement. The various decisions cited by Mr. Sir clearly indicate that there are several decisions has been, my lord, shown in my lord. In this case, my lord, that is in my lord, para 22, my lord, onward, my lord. I am not reading all these things, my lord. Innovation alternative area. The various decisions cited by Mr. Chakraborty would clearly indicate that constitutional power vested in the High Court or Supreme Court cannot be fettered by any alternative remedy.
This is a self-restraint.
Yes.
This is a self-restraint by 226 court.
Yes, sir.
It is not a rule
Yes, sir.
that alternative
Yes, sir.
remedy will exclude the power of
Yes, sir.
226 Court.
Yes, sir.
However, the Supreme Court in many cases qualified certain conditions
Yes, sir.
like violations of fundamental rights.
Yes.
Then order passed by the authority having no jurisdiction.
Yes.
And thirdly, the principles of natural justice. These three criteria
Yes, sir.
are
Principle of
qualified to be
principle
the
of natural justice I am submitting, madam. Before giving that 2018-19, they never said to the contractor, my love, that we are also going to give this 2018-19, my love, addendum in this contract. My love. That is my right under my love, principle of natural justice. Anyway, my love, my right under 19G also violated. Sir. This is a terms and condition of the contract. We, the prudent contractor, my love, submitted these things because here it is available, my love, before 2 months before of the tender. It was decided whether the clause is applicable or not. And thereafter, they have entered into PVC. They come to the conclusion that we are giving that PVC clause of the tender. Otherwise, they said the PVC clause applicable of the bid. They are not using the word bid. They are setting the word tender. So, we, the prudent contractor, on the basis of that matter, we submitted our tender. Now, in the document, which has been uploaded, nowhere said about 2014 GCC, that addendum 2014, which 2014, that was also not available, my lord. Nothing is available, my lord. And normally, with the prudent contractor, what, my lord? As on my special condition and contract and GCC 2019, which has been followed. Because if your law goes to I shall hand over to your lordship, my lord, that it is categorically stated. Yes, ma'am. First part, my lord. If your lordship is GCC, my lord, 1.01. Order presents in a tender.
You see,
Yes, ma'am. This is 2019.
this is the 2019 6/9/2019
Yes, sir.
clause.
Clause has applicability. This condition applicable for all tender contract railway execution work as defined in DPR 2017.
Clause
Or-
space.
Page first page, my lord. Page 1.
Hmm.
Yes, ma'am. Order prettiness in tender in any case difference contract
Just a
decision.
minute.
Part 1, ma'am.
Part 1.
Yes, ma'am. First applicability because this condition contract shall be applicable all tender relay as defined in GFR. Order in a tender contract in case of difference, contradiction, discrepancy with the condition tender contract specification, drawing bill, conforming part shall be that.
So it says that this condition of contract shall be applicable for all tenders and contracts
Yes, ma'am.
of railways for execution of works as defined in GFR 2007.
Yes, ma'am. GFR 2007. And one thing important, my lord, here it is right down, my lord, that it will be prospective effect. 2019 is the prospective effect. If it is prospective effect, my lord, it will come December 2019 tender, my lord. Now they want to that 2014 GCC, my lord. Suppose, my lord, now there is a law, earlier Indian Penal Code is there. Now it was, my lord, scrapped down by the authority and new law has come, my lord. Can they say, my lord, in new offense which has been arised after July 2000, my lord, 24, that no, that will be applicable. This will
Yes.
not applicable.
No.
That is the case, their case. And we made the calculation on the basis of 2009. Everything has been done. And what I go to their affidavit, my lord. I have already shown that, my lord, 2019, my lord. That PVC clause, all work contract. That is, my lord. Yes. Let them show it is a part of my lord contract agreement. It is a part of tender document. They let them show, my lord. if it is not the part of the tender document and other, my lord, they cannot using the hidden criteria, my lord. They cannot, my lord, nullify this clause of PVC clause. And in the tender we have shown, my lord, there are some tender, my lord, other tender where PVC clause is not applicable. They cut down like this.
Hmm.
And one, my lord, another, four, my lord, I'm very sorry, one copy has been bought. I keep it of the citation, my lord. 2021 16 SSC 35, United Limited and others.
20.
2021
Hmm.
16 SSC page 35. Para mile 39.3
Which judgment?
Unitech Limited.
39 point.
Point mile 39 point mile 3 mile 6. All are mentioned mile main paragraph is 39.3 and 39.3 said Article 223(1) the development agreement in the present case mandate prior to resolve to arbitration. However, in presence arbitration clause within a contract with the state instrument provided has not attracted absolute thought to availing Article 226. Next, coming mile 39.3. In determining whether the jurisdiction should be exercised in context, the court undoubtedly has to disputed question fact which depend upon an evidence requiring trial. But equally, it is well established that Article 26 cannot be outstayed only on the dispute within the party of contractual arena. This is the simple reason that the state and instrumentally are not exempt the duty fairly, merely because their business dealing they have entered into the realm of contract. Similarly, the presence of an arbitration clause does not out the jurisdiction in potential all cases to it still decided the case as to whether the request public remedy can justify it. That is my submission. My right under Article 19G has been violated, and I am relying on DLP judgment, my lord. I do come, my. That also, my lord, document. Page 49. See, paragraph 14. 7. 7. 7.
That's them. That's them. Just I'm finding out the judgment.
I am relying other paragraph also from 41, my lord. Our main paragraph is 49. My lord, citation is, my lord, 2006 2 CLT 775. Educom solution and other.
Educom.
Yes.
You want to rely on this which
I am relying on, my lord, mainly 41, my lord, 42, my lord, 46 and 49.
just the citation is
2006 2 CLT 77. Division, my lord.
2006 2 GLT, isn't it?
Yes, my 2 CLT 7.
2 GLT 7.
May I read 40 then one part, my lord?
What
We
is
are-
the citation of state of UP versus Bridge and Roofs? That is not fine.
In
Okay.
in our view,
Which paragraph?
paragraph 49, my lord,
Paragraph. Just a minute.
page 792.
792. 14.
Yes, madam. I am relying other paragraph, but I am reading, my lord. we are unable to persuade ourselves to accept content of learned senior consequences and so that it is not all necessary the governmental agency to notify the secret threshold and the same. Does it mean that selection criteria can be evolved after opening the technical bit would not give room and leverage decision? In our view, even if such criteria is not notified at the beginning, same should be made known interested for submission fee by informing them about the proposed criteria be applied and the methodology in awarding the mark to evaluated and commercial. Here in the instant case, my lord, until and unless I made the claim of the PVC, my lord, they never said about all these documents. They never produced all that documents at any point of time. After I claiming PVC, when they rejected my lord, that also they are not producing all these documents. That this document is applicable, that is why you have been rejected. That was not method. When rejection has been made, that has been method.
Okay. Okay.
And pleading is of it.
Yes.
Procedural lordship.
Preliminary objection. Arbitration.
Lordship.
Yes.
Preliminary objection. The other day, my lord has indicated that lordship I will not go to it. Lordship has indicated. Yes, because my senior brother has pointed out that
We want to give him a patient hearing without a question of mentality being raised. We want to hear him, then only we'll go to the maintainability. Isn't it, Mr. Shetty? Now you are free to argue, including mentality. No issue on that.
lordship.
Because he has addressed the mentality, and if you argue, he will reply. Okay. Yes.
Lordship.
You can rely on you. You are free to argue whatever.
Lordship.
Yeah.
Otherwise, lordship, I have abandoned that.
No, don't abandon. You argue.
Lordship. In respect to lordship, price variation.
On that day, he was a little bit. That's why we stop you arguing.
Lordship.
Yes.
Regarding lordship, as DCC, there is a no dispute. Lordship, the 2019 DCC will be applicable. Even today, 2023 DCC also comes. 2024 is also in the pipeline.
Yeah.
Every year they have. Otherwise, lordship, the price variation clause, lordship, whether it should be the tender value or contract value, lordship, it is already clarified by the railway board in 2014 itself. And even yesterday evening also, I have obtained instructions from the railway board authorities. They have said that the clarification which was given in 2014 is still full. And in
Okay.
respect of lordship, paragraph 5, I have indicated. Paragraph 5 of our affidavit.
Affidavit that I have seen.
That is our
That is your step.
That is our stand, lordship. Otherwise, lordship, that abandoned person is because my brother is. So I am relying only one judgment, lordship.
Okay.
One latest judgment, lordship, in 2015. SP 4408.
Phase.
Well, lordship, I am relying paragraph lordship 6 onward. Basically, alternative remedy part lordship 2.2 is a, one of the statement is there. 2.6
Paragraph.
paragraph 6 onward. 2.2 also there lordship, preparing appeal provision is there lordship. Paragraph 6 onward, lordship, by discussing the various judgment of Honorable Appeals Court lordship, and Honorable Court have finally in paragraph 9 lordship.
Paragraph
Paragraph 9 lordship.
9.
9. After discussing the various judgment of the Honorable Appeals Court in paragraph 6.
Now, where is your arbitration clause?
Arbitration clause lordship, regarding that part, I am not doing. Otherwise, there is arbitration clause is there in lordship DCC lordship. This is even contract agreement lordship.
Okay. What is that clause?
Clause is
Arbitration
there
clause?
lordship, even in dispute. My lord may kindly.
Okay, you just indicate where is that.
2019.
Have you taken any stand in the affidavit that is
No,
not?
Lordship, that part. Otherwise, lordship, there is arbitration clause is there lordship. Probably this is 62. 62 to 5. 2019.
Yeah, sure, sure.
Lordship, it starts from Lordship 63 Lordship, and,
Just,
and demand of arbitration is on 64-1 Lordship. Any dispute Lordship.
just flag mark it.
Lordship.
Give them
That's
flag.
correct. 64, 64-1 is Lordship in respect of demand for arbitration Lordship, and appointment of arbitrators is 64-3 Lordship. Second. Okay.
Okay.
And step 30 of the GCC itself says that it is step 30 in respect of Lordship, price variation and arbitration. And Lordship 46A is a part of the Lordship price variation, and 64 is a part of the arbitration. It's a step 30 of the GCC.
Okay.
Yes, but I
Lordship.
want to give one answer, my lord, that our liner was not properly instructed by the railway
Hmm.
because 18/7/2022, my lord, Railway Affairs has withdrawn that letter of my lord 2018 letter due to many anomalies happen in the railway.
Where is that?
Railway said, my lord, this is still in court. Because this anomalies has been happening in many countries. In respect of, that's why I also for the original.
What is this? The second page, part 1, GCC September 2019. That that book you have given.
They themselves withdraw, my lord, 2023, because many anomalies has been appeared. My argument is that, my lord, 2018 will not come. It's not part of tender document. Nothing nowhere they have mentioned about this letter. And when 2019 DCC has come, my lord, this document has become null and void. And now they have
Yes,
Yes,
Gogoi.
So, again, railway board circular and GTC are two different things.
No, that is not the
Lost,
issue.
lost.
He is relying on, you should give a copy to him. He is relying on a document which says that PVC should be paid as per tender condition and clauses in the particular contract.
Lost.
Withdrawing earlier letter number 2018. So 2000 letter is 18 and it also reflects that don't make recoveries. Further decision may kindly be communicated regarding recoveries, payments thereof, if any, owing to this instruction. Also, audit objection, if any, may accordingly be addressed.
This
So
is
meaning
in
they are-
respect of PVC loss, but whether it's a tender value or contract value loss. That was lordship never.
Now he
That
said
is
that
also-
PVC should be paid as per tender condition
Lordship.
and clauses in the particular contract.
The PVC is as per tender condition and clauses of the particular contract. Is there.
tender.
Now, I am not saying that part. I am saying that lordship regarding lordship, whether it should be a tender value or lordship it should be a contract value. And here it says that it is in respect of the tender condition, whether in
Tender condition.
when-
What is this letter
when
24/6/2022?
my lord may in that purpose
That letter I have done, my lord.
for tender question lordship may
Yes,
tender condition lordship may kindly
This letter
No, just answer us, Mr. Chaudhary. It is a contract, admittedly. It is not a public law remedy.
Yes, sir.
Okay. Now we know our limitation to what extent we can go.
Yes, sir.
How do you satisfy that this is an issue where writ court can exercise its jurisdiction?
I have a Kandia construction. I have my lord. My humble.
No, you come to a specific point that
Yes, sir.
your whole argument is that it is not anything like a serious dispute of
Yes.
technicalities.
Yes, my lord. My
That argument you are not advancing.
yes, my lord.
Therefore, again, I am arguing on your behalf. Is it not?
I am not so complete.
So therefore, it is a interpretation of a contract in a given admitted fact as reflected in their office note itself.
Yes, sir.
So therefore, issue is whether the effect it is on the basis of tender condition or it is on the basis of GCC.
Correct.
Therefore, it is not a dispute to be addressed by arbitrator. And therefore, this is the law
Yes, sir.
in support of your case.
Yes, sir.
Show us that.
That is that judgment has been shown.
Which?
Kandia construction. My lord.
Show us where is that Tantia construction, what Tantia construction says. Yes, paragraph.
Yes, my lord. I have already been my lord paragraph 30, my lord. Then your lord.
Tantia construction paragraph 33 says
Yes, my lord.
that alternative remedy cannot be a bar
I-
for
I am
exercising
reading
power
over
under
earlier.
226.
Yes, my lord. Para 22, my lord. Your lord, come. Mr. So-and-so referred to rely on decision of so-and-so, wherein the same point court held that I could not dismiss the required appellant herein to recourse of arbitration, particularly when virus of provision was not the issue. Reference was also made decision. Mr. Chakraborty submitted that while enacting arbitration conciliation, the legislature has intended arbitration such a private agreed upon by the party themselves to settle their dispute. There should be minimum interference by the regular court in such proceeding. In Mr. Chakraborty refers section 5 of the Effort Act, which indicates that not to insisting anything contained with any other law for time being enforced in matter commanded by Part 1, the judicial authority shall intervene except where so provided in the said part. Mr. So-and-so, the fact discussed revealed that paragraph 25, this is the fact, I am not going to. According to একটা procedural হলো
So issue is whether we can interpret a tender, the
That's fine.
terms of a contract.
That's fine. And other question also, judgment also, I'm coming by like
It's a specific issue. In a
Specific
rich jurisdiction,
Right,
whether a interpretation of the term of contract is permissible in the given facts of the present
Yes,
case,
madam.
more so when they have taken a stand that there is a difference between the contract value and the tender value. Tender value less than 5 crore PVC applicable, not applicable, not applicable. Here tender value was above 5 crore, so it was applicable. According to them, when contract is entered, it was less than 5 crore. Therefore, it should be interpreted that that value will mean the actual value. So therefore, when it is a contract value, then it comes under PVC will not be applicable. Had you quoted a rate above 5 crore and contract was entered above 5 crore,
That's fine.
it is their stand. Answer to that.
Yes, my lord. I am giving answer.
Yes, give the
Answer
answer.
is my lord. Let them show my lord. I am other.
No, you will have to show.
I have to show my lord.
Uh,
Because I am only show my lord. My tender value is my lord 5 crore. That is my submission, my lord.
So therefore, can
yes.
we now
Yes, my lord.
enter into this debate and make an interpretation
Yes, my lord.
when the employer has interpreted their contract?
Yes, my lord.
Give us some
No,
submission.
No, my lord. I am submit, my lord. The tender value as per page 27, it is specifically mentioned it was tender value is 5 crore. Now they
Oh, that we understand.
Yes, ma'am.
Our question is,
I
should
want-
we
I
go
want
to
to-
for this
I-
interpretation
I want
and our power?
Yes, my lord.
That we
Yes, my lord.
understand. That can
I want to submit your lordship, CCL and others. They have to follow, abide by the tender condition of the contract. That is my humble submission before your lord. And they are not following the tender condition of the contract. Now they have produced.
now tell us when there will be a contradiction between the tender and GCC. Okay, fine. That is also.
Tender decision also my support
Okay.
me, my lord. That is my case.
So you want to say in exercise of rich
Yes,
jurisdiction,
my lord.
we'll have to say that the interpretation are violative of
Yes,
which provision of
my lord.
Constitution?
14 and 19 both. my lord.
Article 14 and 19.
Yes.
This is arbitrary exercise.
Arbitrary exercise of power for collateral purposes.
Give us a decision that
Madam.
in case of arbitrary exercise of power, government can read court can exercise it.
Yes, that is the other.
Which judgment? Srilekha Vidyarthi.
Yes. Maintainability of this unit take also my
Heard the parties at length. All them.
if they only thing your lordship will look only one thing, whether they on the basis of tender document on DCC 2019, if they show that it is a contract, there is an interpretation of contract and tender, then my case go. If they could not show, if they are not, document is not available in the tender process, my lord, then my lord, only your lordship interpret what is the condition of tender interpreted, what is the GCC has been interpreted. Many documents can be taken out by the my lord, just like other way, my lord. They I have argue, my lord, 1 month, 2 months, then one notification has come back. That is not right. 39.6, my lord, in the Unitech, my lord. Here that to determining the whether to
Heard Mr. NNB Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Gogoi, learned learned counsel CGC representing the railways. The present application under Article 226 of the Constitution of India is preferred by the petitioner. Assailing and later dated 1/3/2023 issued by the Deputy Chief Engineer within bracket construction, Northeast Frontier Railways, whereby the petitioner was intimated that petitioner shall not be entitled for price variation. The petitioner shall not be entitled for benefit under price variation clause, as the contract value of his tender is less than 5 crore, to be more precise, 4 rupees 45321,255.2.25. Full stop. The basic grievance of the petitioner is that the tender notice, as per the tender notice for execution of the work of construction of 12 numbers double-storied type Roman 2 quarters at Bongaigaon and Borpeta Road, etc. As per the tender notice, the tender value was fixed at 5611041.8.74. Full stop. In terms of the clause 6 of the tender document, tender condition, price variation clause is not applicable for tenders having value less than 5 crores. And therefore, it is contended by Mr. Chaudhuri, NNB Chaudhuri, Learned Counsel, for the petitioner that in view of such clear provision of tender value being over 5 crore and condition clause 6 of the tender, the petitioner was entitled for price variation clause, and therefore the petitioner offered his rate on the basis of such condition. Mr. Chaudhuri further contends that the pursuant to the tender, a contract was executed between the petitioner and the respondent railways, inasmuch as the petitioner offered a value for execution of the contract at rupees 4,5321,255.25 and accordingly a contract was executed between the parties on 28/8/2020, and clause 46A of the contract prescribes that price variation clause within bracket PVC shall be applicable only in those contracts where tender conditions specifically permit its. Referring to such clause, Mr. Chaudhuri contends that such clause 46 capital A.1 clearly stipulates that the price variation clause applicability / availability of price variation clause is to be decided on the basis of the tender condition, and in the case of the present tender, the clause 6 of the tender condition clearly stipulates that PVC shall be applicable when tender value is more than 5 crore. Full stop. Accordingly, Mr. Chaudhuri contends that when it is clear that tender value is more than 5 crores the price variation clause shall be applicable in the case of the petitioner, irrespective of he offering lesser value than the tender value. According to him, there is a marked distinction between the tender value and contract value. However, both the condition stipulated in the tender as well as in the special condition of contract, it is prescribed that it is the tender value and stipulation in the tender condition which shall determine the applicability of the price variation clause, and therefore the petitioner in the given facts of the present case is entitled for price variation clause, benefit under price variation clause. Mr. Chaudhary further contends that even clause 46A of the general condition of contract of 2019 substantiates such claim and substantiates such claim. Therefore, the rejection of such claim of the petitioner for price variation on the ground of a determined decision made by the railway board in the year 2014 and subsequent notification, subsequent order issued on 2018 cannot be a ground of such rejection in derogation of the tender condition, conditions under special condition of contract and the conditions under GCC. Inasmuch as the GCC 2019 was incorporated on 6/9/2019, and such condition nowhere stipulates the determination of the purported determination of the railway board and the subsequent communication issued in the year 2018, prescribing that it is the contract value, not the tender value, which should be basis of grant of price variation clause. This is your argument. Per contra, Mr. K. Gogoi, learned counsel, submits that the contract submits that though a question has been raised as regards interpretation of the condition of contract as well as tender values, in terms of the GCC, SCC, and tender condition, the petitioner is having an alternative remedy of arbitration, and therefore this writ court, in exercise of its power, shall not may not like to exercise its extraordinary jurisdiction to decide an issue relating to private law remedy and not to public law remedy. Mr. Gogoi further contends on merit. Mr. Gogoi contends that the railway is not guided by the GCC, rather it is only guided by the contract agreement and the value of the agreement and value of the contract. And when the value of the contract is less than 5 crore, the petitioner shall not be eligible for PVC at all. Mr. Gogoi also contends that Mr. Gogoi further contends that referring to the affidavit in opposition filed by the railways, further contends that the amount of applicability of PVC has been increased with up to above 50 crore by a policy issued by the railways. 5 crores by a policy issued by railway dated 8/2/2018. In terms of the said policy has been issued in terms of the clarification given by the railway board and prescribed that contract agreement value should be basis instead of tender value, and such clarification was made on 15/10/2014. And therefore, the contract agreement should be read with the decision of the Railway Board dated 15/10/2014, and petitioner, being a prudent businessman having contract with the railway, ought to have been aware of such condition and would have offered such rate. The petitioner, being a contractor, must be aware that it is the contract value, not the tender value, on the basis of which the PVC shall be made applicable. PVC shall be made applicable, inasmuch as such clarification was issued on 15/10/2014 by the Railway Board itself, that is prior to the issuance of the tender and the 2019. Full stop. Accordingly, Mr. Gogoi submits that this writ petition is liable to be dismissed.
What?
Par contra, Mr. While replying to the contentions of Mr. Gogoi, Mr. NNB Chaudhuri, Learned Counsel, argues that in absence of incorporation of the purported policy of the railways dated 15/10/2014 being incorporated in the GCC, which was issued in 2019, the same cannot have a binding effect upon the petitioner, inasmuch as even in the SCC there was no clarification as regards the contract of tender as regards the policy decision dated 15/10/2014 or 8/2/2018.
What?
That being the position, such hidden criteria cannot bind the petitioner.
And
In
it-
support of such contention, Mr. Chaudhuri relies on the decision of Educom versus Swencho.
Yeah.
And
Yeah.
Tantia is different. Don't rely on that.
And otherwise,
And no other is required.
and one thing is
Given
in
conscious considerations to the learned counsel for the party. Okay,
in affidavit, he has not raised the question of
we'll take note of that. Now you will have to answer that these issues can be answered in a article hard in part for further hearing on which date. You will have to satisfy that this is in violation of Article 14 and therefore we can entertain. Otherwise not. In absence of arbitration clause. Will then otherwise will dismiss that this is in the realm of private law remedy, will not entertain. Until and unless you can show it's a violation. Give it, give it. So we have recorded your argument, only this part, so that we can dictate the later part.
14.
14th. I'm keeping all this.
Lost it, lost it.
Or you take it back. I have already recorded. You take it back. Accept the judgment. I'll find out judgment for you. Yes. Okay, do one thing. Next Tuesday.
Because
Okay.
regarding that currency of punishment, my lord,
Uh,
I have to place some
okay,
judgment.
okay, you place some judgment. Just correct us the facts. Give a copy
My lord.
of these to both of them. Okay. Give her 2 copies. Ask not, or give a Xerox copy. Give it to them. Whether anything on facts are correct or
My
incorrect.
lord.
Okay. Please this matter as agreed to by the learned counsel for the parties. On the prayer of the on a joint prayer of the learned counsel for the parties, please this matter on 12. All right. Yes. Yes, Bhattakur. Item 10. This is.
This is your next.
We have already dictated.
I want to place 2 more judgments. for a copy of the judgment.
Tulsiram Patel.
I have brought book.
But what? Where is the other side? Name shown. Forget about it. Yes, you proceed.
Your lordship has already gone through the order.
Order was at page
For page 30,
30.
31. In pursuance of the order of the judgment against.
So this was his dismissal. Now you have been acquitted.
No,
Okay.
that has been earlier. It was your lordship. It was 498. It was converted to 498. Your lordship will kindly come to page 29.
Page 20.
Initially, it was under section 306. Page 29. Your lordship, para 10.
Yes.
They are sentenced to under 1 year of RI for their conviction under 498.
Maybe part of our timing. The RM does the isn't like.
After some time. No.
Maybe. But if we have been duly included in this case, your lordship, as section number 6, NECI. But if we want 2 weeks time to open inspection whether the road is constructed by us. Otherwise, your lordship, it's like this.
That I've seen that.
Lord.
Whether fair compensation should be given.
Lordship. And your lordship, the issue is your lordship, whether your lordship, when there is a finding of fact by the competent authority, they have virtually reviewed their earlier order, whether that power is there or not.
What kind of affidavit do you want to file?
Lordship, we have been newly
Impleted.
completed, your lordship.
We have seen that order dated 12/2.
Lordship. In fact, your lordship, the payment has been made, your lordship. Thereafter, they say that there is while doing calculation, your lordship, the multiplier applied, they have wrongly applied the multiplier. And multiplier, your lordship, is this, your lordship, within the 10 kilometers within the town urban area, your lordship, it should be 2, and beyond that 1.5. Now, your lordship, for that, your lordship, they say that has been wrongly applied as 2, your lordship. It should be 1.5. While doing so, your lordship, no notice has been given to us. Number 1, your lordship. Because it is a finding of fact, I must get an opportunity to, your lordship, defend my case, your lordship. And secondly, your lordship, whether they have that power of review, your lordship, their award. Ultimately, they have reviewed their award, your lordship, but neither in the NH Act nor in the 2013 Act, your lordship, this power of review is there, your lordship. And there is a judgment to this effect from the Honorable Apex.
Okay, since they
Lord,
have implemented,
Lord,
we will have to give them a
Lord.
chance, is not it?
Lord.
When?
After 2 weeks, your lordship.
Okay, pursuant to this court's order dated 12/2/2024, the National Highways Authority of India has been implemented as party respondent, and Mr. Who, your name please?
R. Borot.
As R. Boro has entered appearance on behalf of the
C. Borot.
C. Borua. Mr. C. Borua, Learned Counsel has entered appearance on behalf of the said
That's number
respondent. Full stop. And the Learned Counsel for the respondent, newly implemented respondent, prays for 2 weeks time to file affidavit. Prayer is allowed. Please this matter on.
Lord.
28th of March. Please do this land acquisition.
Obliged. Deeply obliged.
Yes, Mr. Sharma.
May pick up.
Hmm.
Roughly, you have seen the order dated 12/1/4 month.
7 to 10 affidavit is filed.
Here what we want to buy annexer A. No confidence notice of motion was sent to the deputy commissioner by 9 members. Finally, there are 12 members and 2 ex officio MP and MLA 14.
Just a minute. How many petitioners are here?
9.
Total, what is the total member?
Including MP and MLA 14.
Total 14.
Elected are 12 and
Now,
elected
where is the notice?
notice annexer A. 1/12/2023 to Deputy Commissioner Minor.
Page 19.
19 years.
Now, you have given it to Deputy Commissioner.
Yes. My lord,
Now,
the subject is no confirmation motion against the chairman. And last paragraph. In light of the above, we honestly request your intervention in to terminate Mr. Lavanya Dole, chairperson, and appoint a new chairperson through democratic process with full concern of the board and take appropriate measures as with the board members collectively bidding.
okay, now what happened thereafter?
Thereafter, my lord, you will have to come to NXLP. We send a reminder to the deputy commissioner on 7/12/2023. It's very important of regarding no confidence motion. A copy of the no confidence motion that has been submitted previously is also included for your perusal. This is a reminder. Then my DC forwards the same.
At page 22.
Yes.
Now,
Yes.
who is to hold this meeting?
My lord. Yes. Page 20 is the forwarding of petition submitted by the ward member, commissioner. With reference to the subject that above, please find enclosed here with a copy of the joint petition dated 1/12/2023 submitted by the vice chairperson and other ward members, Silapatha Municipal Board of no confirmation motion against the chairperson. In this regard, you are to convene a board meeting as per the provisions of Assam Municipal Act 9 as amended within 15 days for the date receipt of the letter. Copy of the minutes proceedings of the meeting to be submitted to this office. This is for your kind information. This is the DC simply sends the notice to this chairperson because chairperson should call the meeting as per the following law. Then my lord, chairperson fails to call. 15 days elapsed. Even after the
Who
DC,
is not holding this meeting? Why meeting could not be held?
my lord, a meeting was convened. All 9 members were represented, and my lord, the other side is absent. But in the midst, my lord, what happened? Since there was political pressure, I think the ward members were picked up by police, and some of the we have already lot to kindly see. Meeting was called on 16/5/2024. DC also approved the holding of meeting 4/1/2024. They will also kindly come to annexer F, page 25.
Page
25. On the same day, my lord, from the meeting, my lord, one ward member, Jitendra Kutum, was kidnapped. And then he is untraceable. This to the FIR filed with the opposition in charge. It was received on the same day, but the OC has not taken any action on this. Then second is the complaint made by the chairperson herself, who called the meeting. Vice chairperson, Sarmita Dev. Complaint against SIP Priyanka Bora and 2 other women police persons with due
yes, why you? Why you?
I am from respondent number 7 to respondent number 10.
Who are they?
7 is the chairman, my lord,
Hmm.
and other are the other commissioners.
And yes, hold a meeting.
My lord, if the senior is done, my lord, I'll just indicate meeting has been done, my lord. This entire process is divorced. The
Yes,
principal act.
okay, then
Once
I'll let
the
me-
senior completes, I'll give my.
Meeting has been held.
Meeting has been held. The meeting has failed against him, my lord, and the entire.
Where is
process-
your affidavit?
my affidavit?
Yes, yes, you are the chairman.
I'm the chairman.
Where is your affidavit?
My affidavit?
Huh?
I filed it on 22/2/2024.
I think it's black mark, my lord.
Page 51 is the minutes of the no confidence.
Yes.
51 is the minutes of the no confidence.
Who will produce this record? Who will produce this record of the entire proceeding from issuance of notice till holding of the meeting?
The municipal government of now respondent number 6 is being represented by the executive officer. I am not appearing for the
He cannot vote also. Cannot participate, this will be legal.
Who were kidnapped?
Jitendra, was kidnapped by some spoons pilot,
And
and the item was picked up, photograph is there, in the record,
no, photograph will go.
By the
This
police.
is your allegation.
by the police. And my meeting was disturbed, my lord. Meeting was disturbed. Then thereafter, what happened, 3 commissioners, elected commissioners, and 2 MLA and MP, 5 members. They were set together and for so-called manipulate, my lord. They'll also kindly come to page 34, 54.
We want to have the record.
Yes.
We'll see the sanctity of a democratic process.
absolutely. I will appreciate one thing, my lord, in this case, my lord.
We'll appreciate everything.
That is why I was saying, once the senior counsel, I would have.
We'll
indicated.
appreciate everything,
Yeah,
but
absolutely.
since you have taken a stand that it was held, we'll consider everything from allegation of kidnapping of members to not allowing them to participate. We'll see everything.
Absolutely.
We have
Government
long hands under
through
226.
DC
Yes, we'll produce the record.
Silapathar Municipal Board here, according to their petition, is represented by the executive officer, and therefore I cannot.
But from where did you get this copy? Tell us.
I am 7, 8.
Yeah.
In the personal capacities, they have made 7, 8, 9.
From
10.
minutes of the meeting, from where have you got it?
My lord, I am the chairperson against whom the minutes of the meeting was passed.
Huh.
So I have got it from the office of the.
In what manner it was given to you?
Yes, my lord,
Where is your statement?
minutes of the meeting.
Where is your statement? How do you got it? So if you are the chairman, according to you.
I am the chairman. Here they have made executive officer being the representative of the. My lord,
No, that is a different issue. I am asking who will give the copy of the minutes and the record.
If your lordship directs, I can bring. But they have.
No, I am asking who will give this copy to us. Forget about the direction. Who is the authority to give us? Then only we'll direct.
My lord,
Who is the authority?
I'll ask the chairperson, because the chairperson by name I am representing, my lord. I'll ask the chairperson to, if your lordship, to send the entire record.
Better, your lordship may direct the DC, deputy commissioner, he is the head of the district, my lord, to produce the record before this court.
My lord,
Government advocate.
my lord will see their respondent number 6. My lord will kindly see their respondent number 6.
Who was representative of the deputy commissioner in the meeting?
Deputy Commissioner is not a part of the municipal board meeting, my lord.
But there was a deputation of an additional deputy commissioner to be present in the meeting.
My lord, that is why I was saying that this entire saga which they have initiated is something alien to the municipal administration. From where Deputy Commissioner paratrooped into this proceeding.
Okay. Okay, take down. Heard Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr. M.S. A. Deka and Menchuk Biswas, M. Biswas, Learned Counsel for the respondent number
7 to 10.
7 to 10 and S. Borua for 1 to 5.
6 is the authority, perhaps, my lord, who will produce the record.
Who is 6?
No, that is what 6, nobody is represented.
Who is 6?
6, my lord, will see.
The chief officer, government officer, is a-
Huh? Who is the executive officer? Okay, you can appear.
Then he can
See, rest of the respondent. No? The petitioners have preferred this writ petition aggrieved by an action, alleged action, aggrieved by an alleged action on the part of the respondent authorities in not permitting the petitioners to conduct a no confidence motion against the respondent number 7. This court, under its order dated 12/1/2024, issued notice of motion, full stop. Accordingly, the respondent number 7 to 10 are being represented before this court. The respondent number 7 to 10 has filed an affidavit contending that the meeting was duly held and such no confidence motion brought in by the petitioners herein was lost. Petitioner is lost. On the other hand, the learned counsel for learned senior counsel, on the other hand, the petitioner, by filing an additional affidavit, has contended that the meeting was not allowed to be held and 2 members were even kidnapped and 2 members were even brought to police custody and
one was kidnapped, one was brought.
one was kidnapped and one member was kidnapped and one was brought
Vice chairman was kidnapped.
by the chairman and other was
He's saying,
that is his submission.
Yes.
Is it our finding?
no, he said police, not chairman.
No. And other was taken by the police and thus debarred the members to enter into the meeting. Debarred the members into entered into the meeting. Full stop. The learned counsel for the respondent 7 has also produced a part of the minutes of the meeting purportedly held on
5.
Huh?
Same day.
5/2/2024.
5.
5/1/2024. In the aforesaid backdrop, the deputy commissioner, that is respondent number, deputy commissioner Dhemaji,
Him, I-
deputy commissioner Dhemaji shall preserve the record pertaining to the no confidence motion and produce the same in original before this court. From the record, it is seen that the deputy commissioner has deputed one deputy additional. Where is that? Where is that?
uh,
Yes, deputed, authorized, delegated. Where is that?
so page 24.
It is seen that the Deputy Commissioner Dhemaji, by his order dated 4th of January 2024, deputed
Ityajit Pukan,
deputed one Biswajit Pukan, SCS, District Development Commissioner Dhemaji, as the representative of the district commissioner to attend the meeting to be held, to attend the aforesaid meeting. Whether that person is a, and therefore the deputy commissioner shall also file an affidavit and produce the record on the next date fixed. Please this matter on. But suppose he says that meeting was held, you say that meeting was not held.
My lord, I'll show from the.
Okay, we understand. Now, do you need not challenge the sanctity of the meeting itself?
That's the crux of the.
That we, you know,
I think you need to file a press writ petition. Or maybe whatever the remedy. Anyway, we are not going to in that stage, but we want the record to be there. Then we will see whatever. List this matter on.
very open. Already funds are being diverted by the chairman.
My lord, these petitions they are making, there is nothing in the writ
Yes,
petition.
my lord, there is general notice issued
Huh?
by the house. They can
Give a date. This is a democratic election. If they have lost it, lost it. If they have, there is a manipulation, we'll see it on.
Yes.
That's all. You want the record. 22nd.
The writ petition was filed below
Hmm.
on 7/1/2013. When there was a move to acquire petitioner land covered by permanent land acquisition case for 12/2006. I was taking advance for land. Clear violation of the provisions of the property land acquisition.
Hmm.
Like the other PLA cases in which the land was taken without
Now, according to you, without any award.
permit. In fact, whatever the awards have been passed, those were passed expert without giving any opportunity to vary either under section highway or section 11 or section 9.
Hmm.
And in all these cases,
There is an I8 for amendment of the written.
Ah.
only the prayer they did because the pleadings are already there. It can be taken up along with the writ petition itself.
What was your primary prayer in the main case?
The main case, there was a prayer to apply the copies of the award, expert award, so that the petitioner can approach the reference court.
Hmm.
Because the petitioner was under the impression that the awards have already been passed, so certain payments were made. Neither the copies of the notification nor the copies
No. What is the challenge in the writ?
of the petition, there were
Forget about the reason for the time being. What is the challenge?
challenge was since the awards have been passed without affording it, without supplying the copies of the award, thereby the petitioner right to seek reference has been taken away. So the direction may be issued to supply the copies of the
So that you can prepare a reference.
Sure.
So that you can prepare a reference.
Yes.
Yes.
That was one part.
Hmm.
And the second part was that since there was a proposed action to acquire petitioner's land in respect of PLA case number 12 of 2006
Hmm.
without following the due procedure of law. So they may be
That
following
entire proceeding was challenged. PLA 12.
and that was stayed by
Hmm.
status quo and that was abandoned during the pandemic.
Hmm.
In fact, there is no issue regarding 12.
12 is gone.
Now the remaining 5 cases,
Hmm.
this honorable court showed, realizing that there is a violation,
Hmm.
he should 6-7 orders, directing them to produce the documentary evidence
Hmm.
regarding compliance of section 4,
Hmm.
regarding compliance of section 5, regarding compliance of section 6,
Hmm.
9,
Hmm.
and 11. Accordingly,
They file affidavit.
documents were filed,
Hmm.
and in reply thereof,
it was apparent from the document filed by them that there is no compliance of the any of
So facts remains the same. You challenge and one award which has now become infructuous.
Yes.
PLA 12.
Yes.
A proceeding PLA 12.
Yes.
Now other parties that you challenge some other proceedings on the ground that there is total violation of the procedure laid down.
Yes.
Okay. Now after they file affidavit, you are doubly assured that it was violated.
Yes.
Now you want an amendment.
Amendment of the prayer, my lord, because the pleadings
Amendment
are
of the
already
prayer.
included, incorporated.
Yes, what you say, Mr. Mujum?
Implement just now I have it is taken up next week Monday.
Okay.
Let it be on 19th.
Okay. Mr. T. Mojumdar, Learned Counsel for I had लिखो हाँ. Learned Counsel for the Learned Senior Counsel representing the state submits that he may be granted some time to go through the IA seeking amendment to the WPC 114/2013 and to respond to the same and to file objection if so necessary. So, prayer is allowed to release this matter on 19th of March 2024 along with WPC 114/2013. और WPC 114/2013 लिखते लिखो list this matter along with IAC WPC IAC 720 of 2024 on 19th. Huh? Edition. Edition late.
Okay.
Public.
None appears for the petitioner on call. None appears for the petitioner on call. The present writ petition is filed with a prayer. With a prayer to implement all condition of memorandum of settlement dated 8/10/2012 2012 as well as 8/10/2012. None appears none appears
For one,
Mr. Vijay Talukdar, our senior counsel, is present representing
number one.
respondent number one. As none appears for the petitioner, matter stands dismissed for non-proceedings.
Probably in the meantime, those were transferred.
Those were transferred, NIA one, they were acquitted, nothing. Yes.
Here, I was awarded a word
Hmm.
of a parcel van. Is a train parcel card. So I was awarded a contract under a tender. At the outset, I must say one thing. The contract was executed 2018. The term of the contract was 5 years. That period comes to an end at 23. So as on date, there is a termination, but my contract has
Is
otherwise
over.
left. But the issue of whether the termination is legal or not would require some consideration, because what I am saying that the termination is done as per one of the policies, which is the 2014 policy regarding this parcel ban. But as far as I am concerned, I had a specific contract, and contract provided for a manner of termination.
Okay.
So I am saying if you wanted to terminate my contract,
You have to
do it
follow the procedure of the
under the
contract.
contract. So that is the gist of the
Suppose you decide that, what is the benefit or prejudice, not decide prejudice?
But the only difficulty would be this: assuming my termination is kept as it is, and it is not satisfied, there is a possibility of black. And termination itself, my lord, there's civil consequence.
Give a undertaking that this will not be a ground for.
Take up it after 2 weeks. I obtain.
Give an undertaking that this is over, or we'll decide it.
I should obtain it today.
What you say?
With only
Okay,
difficulty
that's why I have asked, what is the prejudice?
that there will be blacklisting in future. I want to do future contract for
Okay. That there is a scope for that doing that,
blacklist.
if it is not decided. Okay, okay, what about your representation?
It's not. I
Why
have made
don't you
repres-
decide, including the blacklisting, then they can immediately know.
I have not made a representation of blacklisting.
You
What
can
I
make a phrase, okay, later the instruction. Okay,
only the interim maybe
okay,
interim order.
okay, that we have seen, 27.5,
22.
22.5,
27/5/22.
or 27.5/22, yes. MS B. Sharma Learned Council for the respondent. Takes further time to complete her instruction. List 21st of March. 21st of March. Otherwise, you'll hear on that 21st of March 2024. Interim order pass earlier shall continue till.
I'm good.
Okay, you proceed. Will not come back at 2. List is over. We'll complete the other work. Yes.
Doctor has seen the order. Your Lordship.
You wanted to rely on the judgment?
Before that, if your Lordship takes up the service manual,
Sub-service.
discipline and appeal rules,
Discipline and appeal rule.
Rule.
Which rule?
Rule
10.
rule. Notwithstanding anything contained in Rule 9, where a penalty is imposed on a government servant on the ground of conduct the state is convicted of a criminal or this we are not expert to.
Where a penalty is imposed on the government servant on the ground of conduct which is led to criminal
Criminal
conduct. Okay.
Then your Lordship, the disciplinary authority may consider the circumstances of the case and pass such orders thereof as it deems fit. Crux of the case. This Rule 9, if your Lordship reads, along with 311, your Lordship, proviso, second proviso, 311 to your Lordship of the Constitution of India.
311. Constitution. Constitution 9. Three hundred 11.
No person who is a member of a civil service of the civil. Then 2. No such person as aforesaid shall be dismissed or removed or reduced in rank except after inquiry, which he has been informed of the charges in his name, given a reasonable of those charges. Then first proviso, we can skip. Then second proviso, provided further that this clause shall not apply
we are considering A again. So where a person is dismissed or removed or reduced in rank on the ground of conduct with conviction on a criminal. I will not say this have to read along with it.
10.
You 10 will have to read along with this. Now three punishment can be given. Now whether this punishment is the dismissal or reduce in rank, which will be applicable? That is why your lordship
They will have to apply its
apply
mind.
fine.
So therefore we have recorded, we'll
Lord.
just relegate them
Lord.
to decide.
That
That's
is
all.
my case. And your lordship, this judgment, your lordship,
Hmm.
says this, your lordship, this
This Tulsiram Patel.
Tulsiram
Where is the paragraph?
paragraph, your lordship. Your lordship may kindly para 114. Before that, your lordship may also 110. This is in respect of a perimetry of provisions in railway servant. And it has in fact, your lordship, overruled the judgment passed by your lordship, the apex court itself, your lordship. This has been referred. Why? In that case, your lordship, relying on this rule 14 of the Railways Act, your lordship, it was said that notice will have to be issued to the
Now 110 is the perimeter under
Very-
rule 14.
lordship will find. Rule 9 to 13, where any penalty in railway servant on the ground of conduct which is said to is conviction on a criminal charge, then rest is not required. Then provided disciplinary authority may consider the circumstances of the case and make such orders thereon as deemed fit. Then your lordship may kindly come page para 113.
Just a minute.
Para 113, your lordship, for the Thalappan case there is reference. Then next page, your lordship may kindly come. I am relying on next page. Such an inquiry, your lordship.
In
That-
Salappan's case, first paragraph, then
that-
quotation,
Quotation,
then this quote pointed out.
then your lordship, such an inquiry. Start.
The quote is into the quote then pointed out.
The word consider has been used, then your lordship.
Then stated.
there
Which
is a-
which
Start with the word such an inquiry. Page
The-
490.
490.
Lord.
Okay, I was at 490. 490
Such an inquiry.
maybe all this quotation and all. Line from top bottom.
Your lordship. Your lordship told it. I am your lord. I will show that, your lordship.
You are having it as SCC
FCC on.
SCC online.
Lord.
Okay, just a minute. Okay, give him the book. Give him the book. Just play pencil mark it.
The word consider has been used in contradistinction to the word determine. The rulemaking authority deliberately used the consider and not determine because the word determine has a must whether. The word consider merely connotes an active application of mind by the disciplinary authority after considering the entire circumstances of the case in order to decide the nature and extent of the penalty to be imposed on the delinquent employee on his conviction on a criminal charge. This matter can be objectively determined only if the delinquent employee is heard and is given a chance to satisfy the authority
regarding the final order that may be passed by the state of. In other words, the term considers all objective pros of the matter after hearing the agreed party. This was the view that was taken in Salappan case. Such an inquiry would be summary inquiry to be held by the disciplinary authority after hearing the delinquent. It is not at all necessary for the disciplinary authority to order press departmental inquiry, which is dispensed under Rule 14 of Rules of 1968, which incorporates the principles contained in Article 311 to provide where the provision confers power on the disciplinary authority to decide whether in the facts and circumstances of a particular case, what penalty, if at all, should be imposed on the delinquent employee. It is obvious that in considering this matter, the disciplinary authority will have to take into account the entire conduct of the delinquent employee, the gravity of the misconduct committed by him, and the impact which his misconduct is likely to have on administration and other accentuating circumstances or redeeming feature, if any, present in the case, and so forth. It may be that the conviction of an accused may be for trivial offences in the case of respondent number so and so, where a stern warning or fine would have been sufficient to meet the exigencies of service. It is possible that delinquent employee may be found guilty of some technical offense, for instance, violation of transport routes or rules under Motor Vehicle Act, and so on, where no major penalty may be expected. It is difficult to lay down any hard and fast rule as to the factors which the disciplinary authority would have to consider. But I have mentioned some of these factors by way of instances which are merely illustrative and not exhaustive. In other words, the position is that the conviction of the delinquent employee would be taken as sufficient proof of misconduct, then the authority will have to embark upon a summary inquiry as to the nature and extent of the penalty to be imposed on the delinquent employee. And in the course of the inquiry, if the authority is of the opinion that offence is too trivial or a technical nature, may refuse to impose any penalty in spite of the conduct. This is a very statutory provision which has been enshrined in this rule, and one of the purposes for conferring the power is that the cases where disciplinary authority is satisfied that the delinquent employee is a youthful offender who is not convicted of any serious offences, those poignant, petty and with a real repentance, he may be dealt with in light years. This appears to us the scope and ambit of this provision. We must, however, hasten to add that we should not be understood laying down the last part of Rule 14 of Rule 1968 contains a license to employ convicted or serious offences to insist on reinstatement. The statutory provision referred to above merely imports a rule of natural justice enjoining and for taking final action in the matter of interest to the hard and circumstances of case may be objectively considered. Now you will see 114. So far as Salappan's case is concerned, it is not possible to find any fault either with the view that neither clause A of the second proviso to Article 311(2) nor clause 1 of Rule 14 of the Railway Service Servants Rule is a mandatory, or with the consideration which have been set out in the judgment as being the consideration to be taken into account by the disciplinary authority before imposing a penalty upon a delinquent government servant. Where a situation envisaged in one of the three clauses of the second proviso to Article 311(2) or of an analogous service rule arises, it is not mandatory that major penalty of dismissal, removal, and reduction in rank should be imposed upon the concerned government servant. The penalty which can be imposed may be some other major penalty or even minor penalty depending upon the facts and circumstances of the case. In order to arrive at a decision as to which penalty should be imposed, the disciplinary authority will have to take into consideration various factors set out in Salappan case. It is, however, not possible to agree that in second part, your lordship,
That Rule 14.
Rule 14
That is page 14, 491 part that quote is quoted.
Lordship.
The
That
argument
is not
was to the that was rejected.
Reject. Notice part is they can take your lordship
This is-
part of decision, but they will have to apply their mind and see the factors. That's basically the what is.
Basically, this is the determination at page 114.
Lord.
Other part Salappan is decided, and this is 14 is the consideration is
Lord.
concluded. That's all.
And your lordship, one judgment, your lordship, it is on your lordship. Even in such case, your lordship, proportionality will have to be considered. Whether it is commensurate with that is your lordship will get 2008 PSCC 273, your lordship.
2008
PSCC
SCC
273.
270 paragraph.
Paragraph, your lordship, I am relying on 7, 8, and 10, your lordship. Small judgment.
Copy. Seven, 8, and 10.
Lord.
So your lordship, that application of mine is not there, your lordship, in this particular case. Therefore, it should be, your lordship, my humble prayer will be to remand the matter back, your lordship, take a press.
Yes, Mr. Das, we'll remand it back. Dispose of. We'll dictate the order, you can get the answer. That's all.